one of the most challenging things about litigation, well, actually, one of the most difficult things, if not the most difficult thing about litigation, is conducting and gathering discovery. Think about it. The plaintiff files a lawsuit and alleges that their rights have been violated. They conduct discovery on the issues to obtain relevant and material information to assist them in making their case. The defense does the same thing. But let's get back to the plaintiff. And in the discovery that the defendant produces to the plaintiff, they do what I call a dump, where the defendant will not only provide relevant information, but sometimes they will provide irrelevant information, and they will be duplicative. And to make matters more challenging, they redact a great number of those documents, claiming that the documents are privileged. And that's what we're going to talk about today, filing a motion to compel the unredaction of documents. And we want to talk about getting the defendant's privilege log. So let's get started. So let's define redaction. Redaction is the retroactive editing of a document to remove confidential material. Attorneys may often need to redact legal documents to protect attorney-client privilege and confidentiality. Let's look at the definition of a privilege log. A privilege log is a document that describes documents or other items that have been withheld in a civil lawsuit under the claim that they contain privileged information. And there are 4 reasons, pro se, why you want to request the defendant's privilege log. Reason number 1. When a party withholds information which is otherwise made discoverable by claiming that the information is privileged or subject to protection as trial preparation material, the party then must expressly claim and also describe the nature of the documents, communications, or tangible elements without revealing information which is privileged or protected. And you'll find this rule in Federal Rules of Civil Procedure 26B 5A. Now, let me also say, you will be expected to prepare a privilege log, providing you will be asserting privilege. Reason number 2. As I said, you can be certain, pro se, that the defendant will allege that the information and documents you request are privileged. And I'm reiterating this, so I want you to be ready. Reason number 3. You can also be certain, again, pro se, that the defendant will redact documents asserting they are privileged. Again, you really want to be ready for this because it can be sometimes draining, but you got to deal with it. Okay, pro se, be ready. Reason number 4. It is critical that you obtain and review the log to determine if defendant identified the purported privileged document or documents in the log. This really could be a litigation changer. So let me illustrate what I mean by litigation changer. Let's look at Nees versus Baptist Memorial Medical Group. It is a June 2020 Tennessee case. Let me just give you the backdrop of this case. Plaintiff is suing the defendant, alleging a violation of federal anti-discrimination law by, among others, withholding his pay, cutting his health insurance, and the defendant ultimately ended the plaintiff's employment agreement. Of course, the parties disagreed about the discovery issues. And on the issue of search, the court ordered the parties to meet and confer, to explore various possible compromises. And the remaining issue the court ruled on was related to the defendant's redactions and whether defendant must produce unredacted versions of 5 documents that were not listed in its privilege log. Let's listen to how the parties went back and forth and how the court ruled on this issue. In its response to plaintiff's motion to compel, defendant contended that the documents were redacted because they contain confidential and irrelevant information that bears no relation to the claims and defenses of this matter. This was the defendant's argument. The court ruled to the extent Baptist, which is the defendant, is attempting to assert some form of trade secrets privilege or other privilege that might cover sensitive business documents, it waived that privilege. Listen to this. When defendant failed to include these documents in its initial privilege log, and when it did not substantively respond to 5 separate attempts by opposing counsel to discuss the omission of these documents from its privilege law. Let me just make a point here. Pro se and defendant, you must act in good faith. If you're going to assert privilege, you need to put it in the law. The parties go back and forth and try to resolve the issue. It must be genuine. In fact, before a motion is filed, the party filing the motion prior to must make a good faith effort to try to resolve it. That's critical. So here again, the defendant waived their privilege. Waived their privilege. You get that? That's the litigation changer I was talking about. Moreover, the court said, this is not the kind of exceptional case in which unilateral redaction is allowed. There is a protected order. Now, this is really critical why the court is making this point about this case not qualifying for a unilateral redaction because the defendant had the opportunity to put a protective order in place. So let's go on. The court said, there is a protective order shielding sensitive business information, in this case from improper disclosure. Defendant has not identified any reason why that order is insufficient to protect its interests. That alone makes relevant redactions improper. The court also examined the breadth of defendant's redactions and cited as an example a 5-page report from defendant's medical executive committee. We referenced the 5 pages. This is what we were referring to, which received plaintiff's request to be reinstated. That's what these 5 pages were about. However, defendant redacted every part of that 5-page report except for its heading. So it's critical that this information is unredacted, right? Remember, defendant terminated plaintiff. Plaintiff asserted in his termination, defendant violated federal anti-discrimination law. Remember? So this is very relevant and critical to plaintiff's lawsuit. The court found that the redactions are not small and do not allow a reader to understand what information has been redacted inexorably raises questions about the document's content. Now, this guy should be familiar. He appears in the video thumbnail. Now, this is an agreement with a force majeure clause. And here's my question to you. What argument would you make for unredacting this document and why? And feel free to post your answer. Guys, we will see you next time. And remember, be empowered. Take care.